So sorry, I'm just as true to form, I'm getting Teams messages through as I'm trying to present in a webinar. So it wouldn't be a webinar without that happening, would it? So sorry, I'm just going to cancel that off. Okay, so for those of you who may not know who Goodwall are, although I'm fairly sure that most of the people on this call will, we've been helping businesses for more than 27 years to establish, grow, or scale in the UK. Our core offerings are across governance, finance, payroll, virtual office, and of course, HR. You have myself and Helen presenting today. Helen is Senior HR Advisor in my team. I'm the HR Manager for those of you who do not know me. And as a brief summary, our HR department can help you with any employee-related matters that you might have. So from initial hiring to exits and everywhere in between. We look after any employee relation issues that you may have, contractual matters, the list's quite extensive. And then we can also help you with any global mobility questions that you might have or training. So if you need anything of that sort, then do reach out to Helen or I or to Nancy, and then we can see what we can do. So enough about Goodwill. Of course, you would need to have been living under a rock to have not heard all of the noise on the drum up to the round up to the general election. But of course, we now have it confirmed that we are now being led by the Labour Party. So they are now the head of the new government for the UK, and Sir Keir Starmer is our new PM. And that means that there is going to be significant shifts in the employment law world. We've been promised that. In fact, Helen and I have been cowering in fear over these promises for quite some time because we're going to be extremely busy. But ultimately, there's going to be a significant shift in policies, a much stronger focus on workers' rights and social welfare. And critically, the Labour Party have promised a very ambitious 100-day turnaround promise. So we expect the King's speech will set out the new government's first programme on 17th of July. Parliament will be taking a break for summer. And that will be a shortened period. It's normally 6 weeks. That will be a shortened period of 4 weeks, where Parliament will reopen on the 2nd of September. So if we are looking at this 100-day period, then we expect that we're looking around the 25th of October to see some significant changes. So it doesn't really give us that much time to start making plans, not to scare you all. Okay, so if I kick off first then, so the first point or first couple of points, I suppose, that we thought were most critical for you guys to start preparing for is this promise of day one rights, and also we have the enforcement extension. So what the day one right pledge is this will focus on removing the qualifying period for ordinary unfair dismissal, also for sick pay and parental leave. So things like maternity, paternity, and shared parental leave, so that they will become employee rights from the first day of employment. So we'll be covering the sick pay changes and family leave types a bit later. For this part of the webinar, I'll focus on the ordinary unfair dismissal points. So what does that mean for you as the employer? Currently in the UK, you may be aware that we have the ability to execute short-term dismissals. So that means for employees that have less than 2 years of service, it is fairly easy to terminate. Obviously, it's not best practice, but it is fairly easy to terminate if you have less than 2 years service. If your employee has less than 2 years service. Unless, of course, there is possibility for them to link their exit to a discrimination claim, in which case that is protected from day one, or if they have any whistleblowing claims that they might want to link to their exit. So, of course, it isn't best practice, as I pointed out, but currently, due to this 2-year qualifying period, there is currently a low risk of any legal issue arising, again, unless the employee can link their exit to discrimination or whistleblowing. So at this time, we don't know exactly what the new legislation will be, but Labour have said that employers will still be able to dismiss employees with under 2 years service for potentially fair reasons, such as capability or conduct. And it also seems that failure to pass probation will also be added as another category of potentially fair reason for dismissal. So, we need to look at what processes you've got in place to be able to do that. So there basically needs to be a proper operation of probation periods to make sure that you can evidence that you have exited your employee legitimately. And you will need to follow a fair and transparent process. So what should you do? So you need to review your internal processes and procedures and your employment contracts and paperwork. So you need to make sure you have suitable policies and procedures in place for managing probation periods. And also you need to have a clear probation period clause in their employment contract. As well as ensuring that your performance management and capability processes are fit for purpose. We need to really bear in mind that best practice is key here. So you need to be documenting progress of your employees, irrespective of whether they're in probation or out of probation. So really documenting those meetings and performance conversations. A lot of times we get employers coming to us to say, you know what, this person's not really been doing so great for a year. And they might have had verbal conversations, but in nowhere is it documented. And actually, in this new world that we're expecting to go into, that is not going to be okay. You're not going to be able to defend a tribunal claim with that background. So if you exit, you need to evidence a fair procedure. You need to make sure you have good recruitment assessment processes in place as well. So maybe consider adding behavioural and cognitive assessments as part of your recruitment process. You know, it's not always a technical issue when someone doesn't work out. It's not necessarily their technical understanding. They just might not be a good company fit. So that might help you to assess at the recruitment phase whether they're going to be the right person for your company. And then we'll also look at enforcement rights. So it's expected that the current time limit period for an employee to lodge a complaint with an employment tribunal, that will increase from the current 3-month period that we have to 6 months. And there's also a hint that there will be the removal of compensation caps as well. So what does that mean for you? But there's going to be a longer wait post an employee's departure from a company to understand whether you will need to consider a settlement agreement or go to court. This paired with the day one rights that we've just been discussing, we expect that there might be a spike in claims of people who may try and take their employer to court. There is that possibility. There isn't an absolute way to prevent an employee who qualifies to take you to court, but the best defence, as I've already pointed out, to be able to defend yourselves if you do find yourselves there, is to follow best practice when you're dealing with any performance processes, when you're dealing with disciplinaries, when you're dealing with grievances. You need to be able to demonstrate fair treatment straight away. So we're keen to see what the new legislation will be. And if a claim is made against you, then Helen or I would be happy to help. We also have a group of great employment lawyers in our network that we can point you to if you should end up in court. And then just one last thing before I hand off to Helen. We might see over time that there could be a decrease in discrimination claims, and we might find that automatic unfair dismissal claims that are whistleblowing might also decrease. But we might then see, as I've just alluded to before, maybe a spike in ordinary unfair dismissal claims. So those employees that have the less than 2 years service now that maybe wouldn't have had the background to be able to make a claim today might now do that moving forward.
Thanks, Jacqui. I'm going to speak next about the proposed increases in national minimum wage. So Labour has pledged to continue with the commitment to raise the national living wage across the board, but with proposals to immediately increase the national minimum wage to at least £10 an hour for all workers, so not just based on age. So Labour are also looking at proposals to ensure time travel, so travel within to different workplaces or travel within work time, to really look at those and to make sure that that's covered. So if people are travelling within multiple working sites, that's covered by national minimum wage as well. And they're also going to look and act on sleepover hours. So in service sectors, particularly in social care, they're really going to look at what constitutes as sleepover hours and how employees are paid for those areas. There's also going to be likely to be a really big focus on banning certain unpaid internships. So they're going to look at really tightening on the rules in terms of what constitutes an internship and which ones of those can be unpaid. So what does this mean for you? So currently, as you may be aware, there are different rates in place depending on an employee's age and whether they're on an apprentice. So if they're an apprentice, they can be paid £6.40 currently, and for those under 18. And for those 18 to 20-year-olds, the current rates for pay are a minimum of £8.60 an hour and £11.44 for over 18s. So it's going to mean that you're going to have to look at who you have, and if any of those are currently being paid less than £10 an hour, then when the new legislation comes in, making sure that everyone is paid the appropriate rates, and really having a look at what impact that might have in terms of cost-wise for you, and making sure you're doing the right thing in terms of your employees and paying them the right rates. So you also will need to work with your payroll team. So if your payroll is run with us, then we'll be able to help you with that to ensure that all of your employees are being paid the correct rates and at least a minimum of £10 per hour. So you will really need to have a look at employees that might travel during their work and how that might impact on their pay for their work, and also those in the social sector, really having a look at maybe if people have sleepover hours, and that may then significantly increase your costs for those in types of industries and that type of work. And then finally, you really have to have a look at if you have any interns, and if they're unpaid, whether they would still fall into the unpaid remit, or whether those interns will now have to be compensated. So looking at how we can help you with those situations. So you'll need to be able to prepare and proactively look at who your employees are, under what arrangements are they employed, and how much they are paid, and then look at and then model what the increase in costs might be for you, and we can help you with that. And then we also have to have a look at what interns that you might have, and how they may now need to be compensated going forward, depending on what work they're undertaking. And again, as I mentioned, if you're using our payroll services, then we can help those, and that will happen automatically through this process. So I'm going to hand back to Jacqui to talk about the next slide.
Okay, so I did mention just in my previous section about sick pay becoming a day one right, so we'll talk about that as well. But currently our statutory sick pay system is structured as payable at £116.75 per week. This is broken down into days. The first 3 days in one sick period are known as waiting days, and from day 4 onwards, we then have the qualifying day for statutory sick pay. So that's where SSP is then given. But the first 3 days, which are the waiting days, are unpaid. So someone that takes sick under an SSP regime, if they take a day sick here and there, then their sick days are always going to be unpaid because they will never qualify for SSP under the current system. So together with it being a low rate of pay, then it's unlikely to be payable to anyone unless they're sick enough to be off work for 4 days or more in one period of sickness. Of course, companies can offer company sick pay. That isn't what's changing, because that's your company policy. That's completely separate to SSP. We're really focusing on SSP only here. So the Labour government are looking to tackle the issue with employees who fall ill, and they basically have to choose between their health and financial hardship. The pledge is to increase the statutory sick pay rate. So I spoke about it being currently £116.75 per week. And they're looking to increase that. We don't know what that will be yet, but there has been talk of increasing it to the same rate maybe as what you pay statutory maternity pay at, or statutory paternity. But at this time, we can't say. They also want to make it available to all workers, including those who are currently excluded because of low wages. So currently there is a requirement to earn a minimum of £123 per week. If an employee doesn't earn that, then they won't receive any sick pay at all when they're off sick. And also they want to remove the waiting days. So we talked about being a day one right to access this, but also being a right to receive sick pay from day one of sickness rather than of day 4. So in terms of what that means for you as the employer, of course, if you need to pay out sick pay when you wouldn't have had to otherwise, then you'll find that you have an increase in costs. Where you currently pay company sick pay already, that includes SSP. It isn't in addition to. But of course, company sick pay is usually capped at fewer days and then SSP is payable thereafter. So you might still find that you've an increase of costs where you have employees who are off on longer sick leave. But also in the today, you will want, well, sorry, not today, but once we know what the SSP will be, and then you'll need to update your contracts and policies. You'll need to make sure that you're tracking absences to make sure that you're paying correctly and that you're also noting patterns and sickness days. So, if we're looking at when employees have taken annual leave and when they're maybe getting their paid sick leave, you might want to just be a bit more on top of that. So you might also see that because of that, you might see a bit of an increase in absenteeism as well, because again, there's that balance of employee well-being and operational needs. So yeah, just maybe make sure that you have some processes in place to be able to track it, I think would be something that you could look at right now, and then we can change policies as and when we have a bit more detail.
Thanks, Jacqui. Next, I'm going to speak about the single status of workers. So currently, we've got several different statuses of employees, self-employed and workers across the board. And there's been a review that's been undertaken, and often employees and businesses don't have the clarification in terms of which part or which status people fall into. And so that can lead to confusion around what employment rights they might be entitled to, and then understanding what protections are in place, and that can become quite complex. So Labour have committed on moving towards a single status of worker and a transition to simplify to a two-part framework. They aim to consult on the differences between workers and those that are genuinely self-employed, so that all workers can have the same basic rights and protections, so some of which we've already spoken about and some of which we'll follow on today. So that's things like sick pay, holiday pay, family leave arrangements, and protections against unfair dismissals. So what does this mean for you? It means that we'll come on to talk about zero-hour contracts in a minute, but overall it means that it's likely that employees will have more rights as a result of this change. It will also give both you and the employees a clearer picture about what their status is. Are they an employee? Are they self-employed? Are they a worker? It's quite confusing at the moment. And so it will give clear instructions in terms of what framework you should be using, and looking at those individuals and looking at which rights and statutes would cover each of those different areas. So we can help with looking at employment contracts. Jacqui and I feel that there will be lots of updates coming later on this year in terms of what should be in an employee or a worker contract, and then what is covered in self-employed. It will also be looking at converting those workers to employees. And again, Jacqui is going to cover off zero-hour contracts in a moment, but also it may look at things like more part-time working, more fixed-term contracts. So trying to give that flexibility that still remains, but also making sure that it captures in the rights, whether you're an employee or a worker or a self-employed. But all of these changes are quite uncertain at the moment, so we don't quite know for sure which direction the government are going to be in. But also going down this path should make it a lot clearer for both you and the employees going forward. But we also recognise that sometimes it won't be feasible. I think it's important that the government do the consultation on this and have an understanding that there are lots of different types of work out there, lots of different sectors, lots of different industries, and they need to keep that flexibility in order to make it work for businesses. And then I think the last thing I wanted to cover on this slide is that you would probably also need to look at those that are self-employed or contractors at the moment, how and if they fall under IL35, and also making sure that you've got the correct paperwork in place for contractors and self-employed individuals. So you've got that clear differential between employees and workers and those that are self-employed. So I'm going to hand over to Jacqui to talk about the next slide.
Okay, so yeah, Helen mentioned the 0 hours contracts. We did actually recently have a focus from the exiting government on 0 hour contracts. So we have the Workers' Predictable Terms and Conditions Act 2023. So that's expected to come into force in a couple of months in September. And this looks to create a new right for workers and agency workers to request a predictable working pattern in certain circumstances. So that will include a condition of having 26 weeks service as being one. But this is notably, it's only a right to request. It's not a default right to secure a contract. So the new government have pledged to ban one-sided flexibility, and thus they have coined it as banning exploitative 0 hour contracts. We don't know exactly how this will look, but the pledge looks to ensure that anyone working regular shifts for 12 weeks or more will gain the right to a regular contract to reflect the hours that they regularly work, that they will have a right to compensation if shifts are cancelled or curtailed at short notice, and that they will receive reasonable notice of any change in shifts or working time. So what does that mean for you? Again, we don't know for sure if Labour will completely ban the 0 hour contracts. They will hopefully recognise that for some businesses and for some workers, the flexibility of having a 0 hour contract is really valuable. Thinking more about people who, companies who hire students or individuals who have other commitments, who don't want a regular hours contracts because they can't commit to those hours week by week. Those who generally just might want a smaller contract because they've only got capacity to pick up smaller shifts. All of those things hopefully will be considered by the government. But right now, we don't know what they're going to say or do. So we suggest at the moment you should prepare for those changes by reviewing your employment contracts. Maybe consider the merits of offering employment contracts with fixed hours to staff who are currently engaged in 0 hour contracts or casual contracts, but in reality, they do actually have regular patterns of work. And then also think a bit more about how you are today tracking the hours that your 0 hours are doing. And actually, do you have a mechanism in place to be averaging out their shifts? Because that's what you need to do anyway for the legislation that's coming in September. So it stands to reason that that is something that you should be doing. I'll hand off to Helen now for our next section.
Next, I'm going to speak about enhanced rights and protections. So I think Jacqui and I have already spoken about a number of proposed changes, and it's really, the theme is to look at the strengthening of the rights and protections of employees. And this section really continues with that. So Labour have committed to really strengthening the existing rights and protections in place for various areas of work. So that would include pregnant workers, whistleblowing, workers that are made redundant, and workers that are subject to the TUPE process. So, for example, they're suggesting that the right to redundancy consultation is determined by the number of people impacted across the whole business, rather than just in one particular workplace. They've also suggested that flexible working requests should be accepted if they are reasonably feasible, rather than the current regulations that set out particular reasons that they can be rejected. And that there's already been lots of changes and a big focus on some of these areas. And some of those changes have already happened this year. So, for example, there's been revisions to the rights to request flexible working from day one, and that there's been extra protections in place for pregnant employees and redundancies. So Labour have recognised that there have already been changes in place, but they have committed to looking and extending those protections and looking at implementing more regulations in place for some of these areas. So what does it mean for you? What can you do right now? So the changes that they're suggesting would mean that you need to be more diligent in the treatment of some employees. So that, as Jacqui has already said, really looking at whether processes that you've got in place, for example, around dismissals or redundancies, to really ensure that they are fair and that they are providing supporting working environments. So again, looking at the contracts that you've already got in place, the employment status of those employees, and making sure that you've got fair and transparent processes in place. How we can help you is having a look at the contracts and policies that you've already got in place, and when the new regulations come out, we can make sure that they meet those requirements. If you don't have those policies in place at the moment, we can help you roll those out to the businesses in the UK and to have a look at what provisions that the individual company wants to put in place. For example, you probably want to look at flexible working policies. If you don't have one already in place, then rolling that out. And if you do have one, then reviewing that to make sure that it's compliant with the new rules that came into place earlier this year. And also you might want to consider enhanced maternity leave policies. So again, if you don't already have one in place, we can help and support you with advice on that front. And you need to think about putting one in place if you don't have one, because of the stricter regulations, and making sure that you've got the right internal checks when you're looking at potential redundancies and any dismissals that you might want to move forward. So I'm going to hand back to Jacqui on the next section.
Okay, so I'm going to look at family and carer leave changes. So the new government are focusing on immediate day one rights for parental leave, enhanced maternity protections and bereavement leave in its pledge. So I did say that we would talk more about this at the beginning of the session. So the enhancements that they've promised include making parental leave a day one right. We're not talking about maternity or paternity or shared parental leave here. We're talking about the parental leave, which basically means a right to take up to 18 weeks leave up to each child that you have up to the age of 18 years at the rate of 4 weeks a year total. So I always get confused on that one. But so there's currently a 1-year qualifying period for parental leave. If we say like non-birth parental leave, it's just a bit easier, isn't it? So if you think of it that way. And then extending statutory maternity and paternity leave. We don't know what that's going to look like yet. And then make it unlawful to dismiss a woman during pregnancy or within 6 months of her return to work, except in specified circumstances. So that's not really too dissimilar to recent changes that were made by the Exeter government anyway, where returning mothers are protected in a redundancy scenario for 18 months from the date that they start their maternity leave. Also, there is a promise focusing on bereavement leave. So currently, unless in the case of child bereavement, where there is access to statutory parental bereavement leave and pay, there isn't for any non-child bereavement cases, there is no defined legal period for time off for bereavement. So companies are expected to give reasonable time off when an employee's dependent dies, and usually dependents would be classified as a spouse or civil partner or partner, parent, person who lives in their household who isn't a tenant or lodger. or someone who relies on them, such as maybe an elderly dependent who they may care for. So normally in those circumstances, if there's a bereavement, a company is expected to give reasonable time off. There's no statutory time limit on that, but actually there's no entitlement to paid leave for this time either. So companies usually have their own policies to deal with that in terms of allowances of time and payment that they may give for this. And I guess you just have to watch the space to see what happens with that, because we don't know at all what Labour will introduce, but we are expecting that there might be a bit of structure around, you know, a few days off, and maybe the payment might be in line with whatever they decide that statutory sick pay might be, if that is going to fall in line with maternity and paternity. Then we also have caring responsibilities. So the new government are also looking to strengthen the rights of workers to respond to family emergencies with paid family and paid carers leave. So if we look at carers leave first, the exited government did make changes recently to carers leave for dependents. So qualifying dependents under this leave type, so not to be confused with like emergency leave. This is not to just go and look after your child if they need picking up from school. This is carers leave. So a person who has a physical or mental illness or injury, that means they're expected to need care for more than 3 months. Someone who has a disability as defined under the Equality Act, or someone who needs care due to old age. So if someone is a carer who has a dependent who falls under those 3 categories, under carers leave, employees can access this type of leave from day 1 of employment, and they're able to take 1 week of carers leave every 12 months, but it's unpaid currently. So Labour are looking to reevaluate that carers leave that was already brought in by the exited government, and they're looking to bring in a statutory rate of pay for this. So we don't know what that will be yet. And then if we look at family leave, so the current legislation on family leave, if we think of it as emergency leave, is, you know, this is when you would take time out to look after a dependent that doesn't sit under the carers leave categories. So the legislation currently says that employers should give reasonable time off in those instances, but there is no fixed time frame for this, and there is no fixed payment that needs to be given for this. So it can just be unpaid as well. So we'll see what changes that Labour want to bring in on that side of things as well. So what that means for you, again, you should start looking at your company policies and employment contracts. Do you have an intention of paying any company paid leave allowances for this, or do you already? Obviously, as and when we know what the defined time periods are by law that you need to give for these leave types, then you might need to reevaluate those policies and your contracts. And also, just in terms of workforce planning adjustments, you probably need to accommodate for longer periods of absence to reflect these extended time periods for things like the maternity leave and paternity leave that I mentioned earlier that Labour are looking to extend. But also, if you have employees who need to take time out for parental leave or bereavement leave or carers leave or family leave, I expect if there is going to be some forced payment of this from companies, that we might see a bit of an increase in people utilising that leave when they need it. I'll pass back to Helen now.
Thanks, Jacqui. I'm going to speak about equal pay next. So it's been 50 years since the implementation of the Equal Pay Act, and Labour have committed to looking at continually tackling the pay gap. So they're looking to implement a regulatory and enforcement unit for equal pay. So that will involve trade unions, and they will seek advice on what the setup of that looks like and then what their aims and objectives should be. They're also committed to protecting the ability to draw on equal pay comparators, where workers' terms and conditions can be shown from a single source. And also larger firms will be required to develop and publish and implement action plans to close their gender pay gaps. They'll also have the requirement to publish the ethnicity and disability pay gaps and that will also become mandatory for employers with more than 250 staff. As discussed already, there's also a plan to review the national minimum wage rates, but also look at other rates, including sick pay, to ensure that they're more equal across the board. So what does this mean for you? So you should start looking at continually pushing the agenda for the gender pay gap and ethnicity and disability pay gaps. With firms with more than 250 staff, you can start to publish reports if you wish, but there's looking to have enforcement and laws in place for companies with more than 250 people to publish these reports and have the action plans in place that I've already talked about. So we can help you with analysis of your employees and the information that you hold on them and their pay, and we can help you formalise these reports if needs be. And we can also provide advice and support on salary benchmarking. So that might be looking at your existing staff, or if you're hiring for a new role or new people, we can help with the benchmarking for those roles across the UK and across lots of different sectors.
Okay, so something that has already been started by our exited government. We have the Workers' Protection Amendment of Equality Act 2010, Act 2023. That's a bit of a mouthful, isn't it? So that's going to come into force in October 2024. So this was already something that was a focal point over the last few years. Actually, we had the Good Work plan that was started in Theresa May's government, actually, that looked to tackle harassment in the workplace, or generally just look at workplace practices, but harassment, particularly with an angle on sexual harassment, was quite a focal point. So previously, because of the intention with this particular piece of legislation, previously employers were only required to demonstrate that reasonable steps have been taken to prevent sexual harassment in response to a claim. However, the new law that will be coming in October will basically look at focusing on that employers have proactively made some reasonable steps to prevent sexual harassment. So they need to really be looking at their policies and best practices, regardless of whether any claims have been made. So essentially, employers are now mandated to take proactive measures to prevent sexual harassment. They must be able to demonstrate their efforts. And also, just to remind you, you do have a duty of care to your employees at work. So this includes their, health and safety, and that includes mental health. And you are responsible for your employees' actions in the workplace, which will include behaviours like bullying and harassment. So as a continuation of the efforts made by the Conservative government in this case, the Labour government has stated that it will require employers to create and maintain workplaces and working conditions free from harassment, including third parties. So this is quite good news, and I will go on to explain why. So basically, they will be strengthening the legal need for employers to take all reasonable steps to stop harassment, including sexual harassment, before it starts. Although it hasn't been mentioned in the New Deal, the Labour government have previously indicated that women who report sexual harassment at work will be provided with the same protections from dismissal and detriment as other whistleblowers. But then also the previous government also sought to implement a new mandatory duty to prevent sexual harassment in the workplace that was expected to come into force in October 24, but this duty doesn't currently cover harassment by third parties. So that's known as vicarious liability. So this was removed in the previous legislation, but it looks like Labour will be looking to reintroduce this as well. So that's something that's really important for you to think about when you have employees who are dealing with suppliers, other third parties. So there will be that coverage as well that will be expected to be part of your policies and your protections in your workplace. So what should you do? we recommend that you review your policies, you get some good quality training on bullying and harassment for your workforce so that you can clearly demonstrate that you've been proactive and you're committed to protecting your employees. And this will then in turn protect you from any claims if should you find yourself in a tribunal because someone has been harassed at work. So a lot of things to think about. And yeah, I think it's a good thing personally that there has been a focal point in this.
Thanks, Jacqui. I'm going to speak about mental health next. So a big part of the narrative that's coming from the Labour Party is focusing on mental health, the impact of COVID and lockdown, but also lots of other things that they want to try and implement and improve across the workforce and across, not just within the workplace, but across lots of other services that are provided. But one of the key points to look at in this aspect is the right to switch off. So there was quite a lot of information that the Labour Party were publishing before they were elected in terms of the right to switch off at work. So many other countries have already taken steps to put legislation in place and the promotion of healthier work practices across the board, and that Labour are going to look at putting regulations in place for the right to switch off. So that means that the workplace doesn't become, working from home doesn't become working 24/7. And I think this is important, and we've seen a big trend in home working and hybrid working, and it's really important to give employees the opportunity to switch off and to have a rest, whether they're working from home, whether they're working on site, or whether they're working in an office. So it's the aim to give the employees and the employers the opportunity to have a constructive discussion about how this might work and to be able to work together on workplace policies or contractual terms that work for both parties. So we've seen in some other countries where they've implemented similar policies where you have the right to switch off at particular times, overnight, over holidays, over weekends. So we'll have to see how this works in practice and how much they legislate and how much they put in as guidance. I also think it's important to look at mental health as well, and what the Labour Party have a view in encouraging and considering mental health in the workplace. So they've made a commitment to look at the health and safety guidance and regulations that are already in place with a view to modernise this to reflect the modern workplace. They've made a commitment to consult with employees, trade unions and organisations to look to put support in place to make sure that the well-being of employees is put at the heart of employers and employees' thoughts, and to also look at long-term health, both physical and mental health for employees. They also look to raise awareness on neurodiversity and review the provisions for stress, mental health and long COVID in the workplace. It's also important to mention here that they are looking at putting provisions in place for action plans around menopause. So that will require larger organisations with more than 250 employees to produce menopause action plans. And that should set out how you will support employees through the menopause. They've also mentioned that they plan to publish guidance for small businesses on measures to consider. So this might be considering types of uniform that are used and temperature controls, but also flexible working practices. So what does this mean for you? So there will definitely be more of a focus on work-life balance, particularly around the right to switch off and the use of technology solutions to aid this. We're also expecting updates on guidance and regulations on the health and safety aspects and around the menopause. So we can help you with providing training across your business. And if you don't already have policies in place around the right to switch off or the menopause, then we can help you review those and roll those out across the UK business.
Thanks, Helen. Okay, so a couple of pieces here. I'm going to talk about fire and rehire and the new focus on trade union laws. So fire and rehire, for those of you that might not know what that is, where an employer needs to make contractual changes to an employee's T's and C's, they should always be approached through consultation and agreement with the employee or any of the employees involved. In exceptional circumstances where there are genuine and pressing business needs and an agreement just can't be reached, employers can sometimes be justified in changing the workers' T's and C's by terminating their contracts and then rehiring them on the new terms and conditions. So fire and rehire. But due to changes made by the Exeter government from this month, the UK will have its first statutory code of practice on dismissal and re-engagement, and that will come into effect. This code will outline the procedures to be carried out when an employer wants to use fire and rehire. And it's clear that this is, through the new code, it's clear that this is going to be a last resort following a meaningful consultation with the employees or their representatives. It is a risky process, and that is recognised in the code. It could lead to costly tribunal claims and reputational damage. But at this time, there is still no ban on fire and rehire. The new government, however, are looking to ban this practice, and that would then be replaced by new laws designed to regulate the practice of firing and rehiring employees. So we've yet to see how that will look, but that certainly is going to make it more difficult for those employers who are not able to agree the changes that they would like to. And then there's going to be a focus on updating trade union laws. So the Labour government have pledged to update trade union legislation so that, amongst other things, employers will be required to inform workers of their right to join a trade union. There will also be there's because of the recent legislation introduced by the Exeter government to restrict trade union activity, the Labour is likely to repeal that. We're likely to see new rights of access for unions, so allowing the unions the right of entry to workplaces in order that they can help to recruit new members and expand union memberships. And they've also pledged to simplify the process of unions applying for statutory recognition. And this would be by lowering the thresholds of support which unions are today currently meant or required to satisfy. So what does that mean for you? So in terms of a trade union aspect anyway, employers who have not previously had to engage with unions will need to be prepared for those new rights. It's very important for employers to adopt proactive industrial relations strategies to ensure that they've got effective ways of engaging with their employees and addressing workplace concerns. And then also non-unionized businesses may want to consider rolling out training and resources for their managers and HR teams who haven't had to deal with unions before, because that can be a very different experience. So, you know, they will need the skills to manage challenging situations and to mitigate the potential risk of union victimization and other legal claims that might come their way. Because, of course, there is a protected characteristic of employees being discriminated against because they are a union member. So we do need to bear that in mind as well. And yeah, many managers, HR, in-house legal teams might have very limited experience of dealing with trade unions, and they might need upskilling in this area. Generally speaking, unless you work in a certain industry area for many years now, it would be quite unusual to be a union member. The UK in general is not really a unionized environment unless in certain industries. So I should imagine that this change might impact a lot of businesses actually. Okay, so I think that was kind of us finished with everything that we know about anyway. But just to highlight that, you know, there have been a lot of promises made by the Labour government. They have they have made 60 HR related pledges, I believe you said, Helen. So we haven't got the detail yet, that hasn't been ironed out yet, but, you know, bearing in mind that we mentioned at the start of the session, there is going to be this 100-day turnaround promise. We will know a lot more in the coming few months. And I guess it means that, you know, we shall need to maybe make some urgent changes within certain businesses. I don't know if there's anything else you want to add there, Helen, to summarise.
Yes, I know, Jacqui, that you and I have been speaking about this for some time, as you mentioned before, but I think there have already been changes this year and coming up later in the year in terms of existing legislation changes and updates to things. But I think it really is watch this space. We both expect that there's going to be lots of changes that are happening later on this year. As you say, we don't quite know 100% what they are just yet. But hopefully today we've put some slides and information in place to guide you through what we expect is going to happen and help you prepare for those changes that might be coming.
Yeah. We do have a question from Richard. Do you know if the national minimum wage will affect apprentices? Is that something that has been discussed yet, Helen? Do you know?
They haven't specifically said about apprentices. What they have said is that they're looking to increase the pay rates to £10 an hour. They haven't publicised or said anything specifically about apprentices. As I mentioned before, they have looked at, or they are going to look at, interns and unpaid interns, but they haven't specifically mentioned anything about apprentice and apprentice rates yet.
Yeah, because there is a sort of a list of approved apprenticeship jobs, isn't there anyway, and job types and descriptions. So I'd imagine that will be retained, but whether they'll keep to the low rate. Generally, what we're seeing for all other areas is they're looking for quite a shift in terms of increases. So I would be surprised if apprenticeship rates weren't impacted in some way. It's my 2 pence. Okay, are there any other questions from anyone else, or don't think there's anything else in the box?
It doesn't look like any are coming through, Jacqui.
Okay, that's fine. All right, well, we'll just leave it there then. If anyone has any other questions or comments or feedback, or then please obviously do reach out to Helen or I or Nancy. Otherwise, enjoy the rest of your day.